All right, guys. My name is Amy Bateman. I'm the Programs Manager with the Office of Client Advocacy. And so my unit, we investigate abuse and neglect in all out-of-home placements above foster care. So treatment centers, residential, hospitals, group homes, shelters, detention centers. So all those that have kids, we investigate all of those allegations of abuse or neglect. We have two main offices, one in Oklahoma City and one in Tulsa, but we cover the entire state with all of the facilities that we get referrals on. So today we're just going to talk about reporting abuse and neglect, kind of some examples of things that need to be reported that you'll see in the group homes and the placements that you are working in. So we'll start with, in the state of Oklahoma, everybody is a mandated reporter. So that's by state statute. That's if you're in your job capacity, if it's family or friends that you see abuse or neglect, or even just walking down the street and you see a stranger. By law, everybody is a mandated reporter. So you can't default that to somebody else. If you see abuse or neglect, or somebody tells you about abuse or neglect, you have a legal duty to report that to the statewide abuse and neglect hotline. So it's any child under the age of 18, and abuse or neglect, will go over those of what needs to be reported. So again, no one is exempt. We understand there are procedures that each facility has in place of completing an incident report or notifying your supervisor, your director. We're not saying not to do those things as well, but in addition to completing your facilities policy, you also need to make that call to the abuse or neglect hotline. Failure to report can be punishable by a misdemeanor. So if the DA chooses to prosecute for failing to report, then they have that authority to prosecute a misdemeanor. There have been a couple cases in Oklahoma. One is a school. There were several officials in a school that were told about sexual abuse going on for years, and they never reported or did anything about it. So it came out that there had been multiple children that had been sexually abused by this staff member. They knew about it, they didn't do anything about it, and then they were prosecuted for failing to report. There was a case in Oklahoma County, with a teacher again. It was a special needs child. She did a great job of documenting the concerns that she had for this child in a notebook. So the child ended up passing away from neglect. She had all this information, but she never shared that information with anybody. So then that teacher was looked at for failure to protect. So you have to share that information that you have with the hotline. Again, your duty to report. If you see it, report it. If somebody tells you about it, report it. Your job is not to figure out if this allegation is true or not. A child has reported abuse or neglect to you of a staff member. It's your duty to report it. So we would do the investigation to find out if that abuse or neglect did happen. So we have a lot of kids, we know we deal with the same kids that you guys do, that will make allegations. Whether they've made this allegation 10 times or not, if they make that allegation again, it is still your duty to report that allegation. They've given you the information of abuse or neglect. Or if you have seen that abuse or neglect, still your duty to report it. Again, it can't be deferred to another party. One of the main reasons is we ask whoever has the most information to report. So the hotline, you can call them or email the information to them. If you call them, they're going to have prompter questions for you. So the person that has the most information is going to be able to answer those questions. I kind of give the example of the telephone game. If we start here and I whisper something, and then everybody whispers it to the next person, by the time it gets to the last person, that information has changed. Details have been added, details have been lost. So if I tell my supervisor tells, the risk manager tells the director tells the therapist, and the therapist reports, you've gone through 5 different people with that information. So by nobody's fault, information is going to get changed and not be accurate of what's being reported. So that person that has the most information needs to be the one to report. And the reports can be made directly to the hotline. The number's on there. There's an email address and a fax number later on as well. It's always staffed. It's always open. Holidays, nights, weekends, doesn't matter. There's always somebody there to take your call. So what to report? So Title 10A has all the statutory definitions for child abuse and neglect. So what we at OCA investigate, it's called a person responsible for the child of interest. So you'll hear people say a PRFCI. So that's the staff member. That's the owner. Mr. Cornelius, anybody, we are able to investigate from the lowest employee to the top. We've looked at owners before. We've substantiated on an owner before for knowing the abuse or neglect was going on in their facility and they did nothing about it. So it doesn't matter who that employee is. We can also look at them for abuse or neglect. One thing that gets kind of tricky are teachers. So if we have teachers that are coming out to your facility and they are employed by the public school system, then we do not investigate them for abuse or neglect. They're not employed by the facility, they're employed by the school system. If something happens with that teacher, it still needs to be reported to the abuse or neglect hotline, and it gets referred to law enforcement. It just doesn't come to our office to investigate. But it still needs to be reported because it still can be investigated, just not by OCA. Also, if there's some contract staff, maybe, there's been a hole that's kicked in the wall or some repairs that need to be done, and the facility has hired a contract handyman to come out and fix that. If something happens with that handyman to the kids, it still needs to be reported. It just wouldn't be investigated by our office. So abuse, the 10A definition of abuse. So that can be any physical abuse. It's also your harm or threat of harm, sexual abuse, and sexual exploitation. When we talk about sexual abuse, we're talking about a staff member to a resident. So there's a lot of peer-on-peer sexual behavior. When we talk about that, that's not the sexual abuse we're talking about. That's from a staff member to a resident. The harm or threatened with harm for the safety. So a lot of times with restraints, we'll look at there may not have been harm, that intention to harm that child, but there still was a threat of harm based on the way that that restraint took place. So that's where we would look at that threatened harm. Neglect is that failure or omission to provide clothing, food, nurturance, medical, dental care, behavioral health care. And then also exposing the child to the use, possession, sale, manufacture of illegal drugs, illegal activities, or sexual acts. So on the possession of manufactured illegal drugs, cigarettes for adults are not illegal. To give to a child under the age of 18, it is not legal for them to have cigarettes. So we would look at something like that. Also, any illegal activities. You can't take them to go, rob a store for you. You can't take them to go do anything illegal. Sexual acts or material. So we had a staff member at a facility that actually worked at was a bouncer at a strip club. Took pictures, downloaded them on a jump drive, and then gave it to the residents to be able to look at those pictures of the strippers from the strip club. Inappropriate, can't do that. So caretaker misconduct is not abuse or neglect. It's more a violation of a policy or procedure, kind of a rule and understated practice. So it doesn't rise to the level of sexual abuse or neglect. So going back to like the cigarettes, if I have a 17-year-old child that has done all sorts of drugs, probably giving them a cigarette as a staff member is not going to be abuse or neglect. That child has had probably cigarettes already. But if I have one of our younger kiddos in our facility that's 8 years old, giving that 8-year-old a cigarette, there's a lot greater risk there than there is to the 17-year-old. So while to the 8-year-old it may be neglect, for that 17-year-old it may be just that caretaker misconduct based on the age of child. So mental injury, emotional abuse. These are your acts or repeated statements to degrade the child. Our kiddos come from a traumatic background. They've done not some great things, most of why they're in the facilities that they are. They don't need to be reminded of their past. They don't need to be told their parents don't love them. They don't need to be told that their behavior, what they've done is inappropriate. They know that. We're here to help them. Denial of food or sleep. We get a lot of questions about this for, well, what if they're acting out during dinner time, or what if they refuse? So when we look at food or sleep denial, we're looking at it as a punishment. So, you had a kid that just ticked you off by something they did. Everybody's getting ice cream for a snack. You're not going to give them ice cream. That's punishment. You can't do that. Because of their behavior, you can't withhold a snack from them. When we talk about if they were escalated during a mealtime, So let's talk about they're actually, maybe in a physical intervention during a meal. They still have the ability to eat later. They may not be able to eat that same hot meal or what everybody was served beforehand, but they still have the right to eat a meal, a sandwich and chips. It has to be more than a snack if they missed an actual meal. So we can't withhold that food for them, even though their behavior during that mealtime may have not allowed them to have the same hot meal. Tasks that are degrading or unnecessary or inappropriate. It goes with kind of some physical punishments and exercise too. This was several years ago. We had a facility, they would make the kids kneel on rice. They would make the kids hold phone books up. Those old punishments that you hear about that they were still using. So we can't do any of those punishments. Exposure to repeated violent, intimidating acts or statements. And these don't have to be directed at the child. We've had staff members that have been involved in a heated argument with a significant other on the phone, and it's taking place in front of the child. We have a lot of kids that come from homes with domestic violence backgrounds. So hearing that argument is going to trigger a behavior or trigger trauma in that child. So just because that argument and that yelling is not directed at that child doesn't mean it's not going to affect that child. And then if that PRFCI, that staff member, regularly ignores or rejects that child. So this is just kind of a blatant, you are ignoring that child. We understand there's times you're going to be busy. A kiddo comes up and says, hey, Miss Amy, I need you to help me with this. Okay, let me finish this and then I'll help you with that. That's not what we're talking about. If you just act like this child does not exist at all, like we're not even acknowledging his presence, we're not even talking to them, that's what we're talking about. You can't just ignore the child. And then the harm or threatened with harm. So providing those illegal substances, improper seclusion or confinement. So this doesn't mean just a confinement room. If you have a kiddo and they're acting out and you're tired of dealing with their behavior or you're trying to separate them from the milieu, you can't lock them in a bedroom. You can't put a chair or something blocking their exit from the bedroom. That's confinement. Confinement and seclusion requires a doctor's order. So you can't block them from exiting the room. Extreme physical exercise is a form of punishment or control. You can't make them run wind sprints or continue to do physical activity that goes beyond limitations that could cause harm to the kiddos. And then giving the residents authority to engage in physical altercations. And this doesn't have to be as a form of punishment. 2 examples. We had a group home that was kind of in the northern part of the state that they actually had like their own fight club. And so the residents would fight every night. And the new residents that came in and they kind of had their fight club champion. We've also had a group home that the staff didn't want to restrain the kids. So they told the other residents to restrain the other residents. So they didn't want to be involved in the physicalness with the residents, and they had their favorite residents that then would restrain the others. So we can't have residents trying to control the other residents. Any questions so far? So physical abuse, that's any injury caused by that PRFCI resulting from beating, kicking, biting, burning, or otherwise physically harming a child. Regardless of intent, it still has to be reported. So depending on the restraint system, the kids struggling, staff being escalated, not being able to control their emotions, there have been broken bones, broken arms, broken legs that have happened as a result of a restraint. The staff member may not have intended to break that child's arm when they engaged in that restraint, but it happened. So regardless of that intent, it still has to be reported. And an injury does not have to be present for abuse to have occurred to that child. So we have substantiation protocols that we'll talk about later, but there's a specific section for if we're looking at physical abuse and there's not an injury present for us to be able to substantiate. So there's additional information we need. We had a kiddo that was being restrained by 3 different staff, 2 on the upper body, 1 on the lower body. And he kicked his legs and it kicked the staff that was on his lower body. It got her in the face. And so she got mad and so she bit the back of his leg. It's clear as day on video. There was no mark or injury, but she still bit him as a result of him kicking her because he was escalated during the restraint. So possible examples of physical abuse. This isn't an all-inclusive list. These are just the main things that we have seen. So a child injured due to the use of excessive force, child struck with a fist, hand, or object, child's airway restricted due to the use of hold. We had one recently at one of our group homes that the kiddo was sitting in a chair and he was verbally arguing with a staff member, and the staff member decided to tackle him out of the chair and up against the wall. So the kiddo's head was against the wall and it was bent like this where his chin was touching his chest, and the staff sat on top of him. So that staff is restricting that child's airway. Placing hands on a child in a non-therapeutic manner. So it goes back to the reasons to be able to, engage in a physical intervention with that child, that threat to harm or to self or others. And then also pushing or shoving the child into a wall or object, grabbing the child by their clothing. Hoodies are very great for that. If a kiddo walks off and kind of sasses you, staff have reached out and grabbed that hoodie, and it can choke kids across. There's been marks left on the neck from that. Improper restraint, which results in or may result in an injury. So again, that improper restraint and that excessive force doesn't have to result in an injury for abuse to have occurred. We've seen staff that have swept kids' feet out from under them to take them, to slam them down forward. It may not have an injury. It still is an abusive action to take that child to the floor. Again, not all inclusive, but just some of the main things that we have seen. So the sexual abuse and sexual exploitation, again, this is a staff to a resident. So making indecent proposals to a child, revealing private parts to children. We had a staff member that she was going out with somebody that she had met online, and she had different pictures of lingerie that she showed the children to ask what she needed to wear on her date. Engaging in sexual behavior with a child or in the presence of a child. So again, doesn't have to happen directly to that child. If I have staff members that are involved in a relationship and they're sitting on the couch and they're kissing and fondling each other, that's happening in front of the kids, and that's inappropriate. Engaging in sexting. We've had staff that have snuck in cell phones to kids to be able to engage in that behavior. Okay, lack of supervision resulting in children engaging in sexualized behaviors. It's not sexual abuse, but it may be neglect. Exchanging inappropriate photographs with a child. Those same staff that snuck in that cell phone were sexting pictures back and forth with the kiddos. Taking inappropriate photographs of a child, aiding or abetting in human trafficking. We don't like to think this happens, but it happens a lot. We've had staff members that it was a female staff member, male resident. It was an OJA placement. He got out. She actually went and cut off his ankle monitor. And they went and got a hotel together. And then she ended up becoming pregnant by him. So she is in prison. So it's not just male staff to female residents. It is both female staff to male residents. So some examples of neglect. Failure to obtain or provide that critically essential medical, dental, or behavioral health care. So if that child has an emergency and needs to go to the doctor, it's the facility's responsibility to get that child the care. There's routine follow-ups and doctor's visits that their workers set up and do things. That's not what we're talking about here. This is that emergent care that then falls on the facility to get for the child. That mental injury, again, those statements that degrade that child or belittle. Seriously inadequate physical care. So we have to give the kids their basic needs, right? They have to have food, they have to have clothing, they have to have shoes that fit, that aren't worn out. Exposure to sexual acts or age-inappropriate material, failure to protect, and threat of harm. So failure to protect, if I see a staff member, the example we gave where the kiddo was pinned up against the wall, there were 2 other staff members that stood there and watched and then walked off. So then we look at them for failure to protect. They saw what was going on with this child. They saw his neck bent and his chin pinned against his chest, but they didn't do anything to help that child. So then they walked off. So they still can be as culpable as that staff that's engaging in that behavior. And we had a supervisor that watched a restraint for over 15 minutes And he just kind of stood by and watched and didn't do anything or intervene in a very abusive restraint. So then we looked at that staff member for failure to protect. So some other examples of neglect: failure to provide that child with essential medications or medical care and treatment. So if there's a certain staff member that's responsible to refill medications, you as a staff too have the responsibility, if you're handing out medications and realize that medication's running low, to let somebody know. Document that you've let them know, so that if something happens and that child goes without their medications, you've documented that you let somebody know that. Harm or threatened harm resulting from a lack of supervision or inadequate ratios. When we talk about supervision of a child, we're talking about their cognitive age. So we have a lot of kiddos throughout the state that have some intellectual disabilities, and they're placed in all the kinds of placements that we have. So if I have a 17-year-old that he functions as a 5-year-old, I need to look at supervision for him as if he was 5. He doesn't have the ability of a 17-year-old to make those decisions. So if he's somebody that's maybe going missing from care, I'm going to look at how to protect him differently than I am a 17-year-old. As far as access to dangerous items, I'm going to look at him as a 5-year-old, not a 17-year-old. And then inadequate ratios. We get a lot of staff that tell us, we just don't feel like we're staffed enough. In the contract and in licensing requirements, there's a minimum staffing, but then there's also to meet the needs of the residents. So if you have a milieu that has a lot of high acuity residents, there may need to be some additional staff. So if you have concerns, let your administration know that, hey, right now we need some additional people to help us out. Allowing child access to potentially harmful materials or objects. We have a lot of kiddos, they're quick, for self-harm or to engage in those behaviors, especially when a lot of the COVID stuff started. We had extra cleaning going on. So we had a group home and they left the bleach out and the wipes, and we had kids eating the wipes. We had kids drinking the bleach. So you have to watch those materials, and they're quick to get them. Leaving child unattended in a potentially harmful environment, again, based on their age, vulnerability, duration, environment, and what's their level of expected supervision. So if we go on an outing, again, I have a 17-year-old who acts as a 5-year-old. You don't let your 5-year-old, just run off around the zoo by themselves without supervision. So you have to look at that age as far as supervision. So some other examples of neglect: that lack of supervision, sexualized behavior. Again, we're looking at the age, vulnerability of that child. And then you should report any disclosure made by a child, regardless if you believe that child's statements. I can give you 3 examples where the facilities did not report the sexual abuse allegations. The kids all said, this staff member raped me, and nobody believed them based on that child's history and previous allegations they had made. Our kiddos make great victims. If I'm a predator, I come into this line of work, I have a kid that's made these allegations before, I have a kid that has this trauma, who's going to believe them? I'm the staff member. So it wasn't reported, and those 3 staff are now in prison for the rape of those children. But they had to wait till they went to a different facility to report those allegations again for somebody to believe them. We don't want to believe our coworkers will engage in this behavior, but it happens. So if a child discloses it to you, you have to report it, whether you believe it happened or not. The examples we've talked about, again, they're not all inclusive. It's just some of the main ones that we deal with. Any questions? Okay. So how to report. So if you have an immediate situation that needs to be addressed immediately with a hotline, you can call that 1-800 number, and that immediately starts the process. You'll get another person on the phone that you can give that information to. They can get that disposition and get that sent out to our office to start that investigation. There's a fax number. It can take up to 24 hours. So what those faxes do is, if the hotline is slow, they'll go to those faxes and then they'll put on those referrals. The email, I know a lot of our facilities use the email. There are certain staff members at the hotline each day that their job is to monitor that email address and to put those referrals on. So the first would be your call, and then the second is the email. And they need to be reported as soon as possible. We understand that things are going on. If the milieu's in crisis, don't step off to go make that call. Wait till things have calmed down or towards the end of your shift when other staff have come on. But it needs to be reported as soon as possible. If you email, we just ask that you put as much information in there as possible because those prompter questions aren't able to be asked to obtain that additional information. So what does the hotline need to know? So that child identifying information, that victim, what's their age? If you have their date of birth and social to provide that, we can search them in the database and find out what history they have. The agent or employee identifying information, that staff member. So you may not know the staff member. We have kids, again, like I said recently, that they go to different facilities and now they feel safe to report what happened at the facility they left. They may not remember that staff member, or they may only remember the first name of that staff member. If that's all the information you have, provide that information. Their custody status, so parental DHS or OJA. The reason this is important is that parental custody residents, we have to contact their parents first. So their parents are not the perpetrators of this abuse or neglect. They have the right to know that their children have been abused in this placement, and we have to obtain their permission to be able to interview their child. Where the abuse or neglect occurred. We had kids that were on an outing. They went to a YMCA and there was sexual behavior in the bathroom at the YMCA. So the lack of supervision didn't happen at the facility. It happened on the outing at the YMCA. So we need to know that information. Part of it is then we can go to the Y. We can look to see if they have any cameras. So to see what were staff doing. Were they there supervising, or were they not doing what they were supposed to? Full details of the incident. As much information as you have. What the resident told you, what other staff have told you, or what you observed yourself. Where the child is at the time of the report. The child may not be at the facility any longer. They may have gone to detention. They may have gone to a shelter. If it's parental custody, they may have gone home. You may not know exactly where that child has gone, but just let the hotline know that they are no longer placed at the facility you're calling about. We're going to initiate our investigation wherever that child is located. Again, I talked about we have offices in Tulsa and Oklahoma City, but we cover the whole state. So if this group home is out in Tipton, which is in the far southwest corner, and we believe that child is there, and we drive down to Tipton and they tell us that child's been placed up in Miami. So we need to know where that child has moved to. If you don't know, we can look that information up before we initiate. And then a description of the injury. Did they have an injury? Did they get medical care for that injury? Was their chin busted? They've been taken to get stitches. Was their arm broken? They've been taken to the hospital. So if there's an injury, kind of what's been done, what's the description of that injury? And then steps to secure the safety of the residents. If that was a staff member that completely went rogue and was abusing the children, all of them has administration come in and remove that staff. Have that staff and child been separated? Is that staff not working right now? What steps have been taken for the safety of the kids? So what happens to the report? So you call the hotline and they're going to take that report. So it can be screened out, which means that it didn't meet that threshold of abuse or neglect. So it could be that caretaker misconduct that we talked about, but it doesn't stop when it's screened out. So for the DHS facilities, we have our facility liaisons that they follow up on those screened out reports. Our licensing also gets a copy of that report. So it may be a licensing consideration. We had a facility that was reported that it was infested with bed bugs. So not abuse or neglect, but it becomes a licensing issue for the actual facility. So then licensing follows up on that to make sure everything's okay. So it can go to licensing, it goes to our child protection service offices, and also the Office of Juvenile Affairs is notified. So Donna Glandon is the Advocate General for OJA, and all of our screened out reports and accepted reports go to her office. So then she contacts the facility to follow up on those screen outs as well. So just because an investigation is screened out doesn't mean that it's not followed up on. If it's accepted, then it's sent to our office for investigation. We assign it to one of the investigators, and then they have up to 5 days to initiate, depending on what priority the hotline set it at. So we have some that we have to go out that same day by midnight, and then some up to 5 days. Depending on the 5 days out, maybe if there's no injuries and that staff member's been terminated, There's no safety emergency for us to respond. But if we have, say, a kiddo that has alleged that a staff raped them and that staff member is still working, then we want to make an immediate response so we can get a safety plan in place if needed. So the specialized placements and partnerships, those are your liaisons. You have your support liaisons and your safety liaisons that will follow up if there is a contract issue, that maybe it doesn't rise to abuse or neglect, but it's a contract. Or they'll follow up on safety plans. So when we come out and do an investigation, if we need to implement a safety plan for not just the safety of our victim we're looking at, but all the residents, then SPPU is going to follow up on that safety plan as well. So our CPS programs, they help us stay forward to OJA since OJA doesn't have access to the same system we do. And then they're going to review for compliance as well. So there have been instances on those screen outs where people have followed up and they've learned more information and they've reported that back to the hotline, and then we've asked for that to go ahead and be assigned as an investigation. So initiation response, this is where the 1 to 5 days depending, 99.9% are going to be made by an OCA investigator. There may be a time that we need that facility liaison to help us initiate with that child. Again, we have 6 investigators for the state. It's never happened, but if all 6 are out in different corners of the state and an emergent response comes in, we may need help initiating that. And then initial contact, again, it will occur at the facility if that child is still there. If that child is not there, then we're going to locate that child at their new placement or at their home to start that investigation process. And the purpose of our investigations is to ensure the safety of all alleged victims and children. We're looking at, for that abuse or neglect, we want them to have the safest possible placement that they can. When we do a safety plan, we're going to work with administration too. We understand that, staffing is tough. It's a tough job. So what's the least restrictive measures we can implement to keep the children safe? So if that's maybe a staff doesn't engage in restraint, or, this staff and this kiddo, they just kind of don't mix, their personalities don't. We'll work to have other staff intervene with that resident instead of the one that, that resident's targeting. We've had kids that have been targeting a specific staff for one reason or another. For the protection of the staff, we'll talk with the facility about maybe moving them to a different unit or a different facility. We want to protect that staff member as well. And then our protocol, we're going to notify the facility director or whoever's in charge at that time of our presence. We're going to go over the investigative process, and we're going to interview that alleged victim in private. All of our interviews are audio recorded. So that alleged victim we're going to talk with, if they give us any other names of witnesses, child witnesses, we're going to talk to them first. Any adults, we're going to talk to them. And then we're going to talk with that PRFCI or that alleged caretaker. So if you're the alleged caretaker, you'll get a document that goes over your rights and responsibilities. And so you have the right to be advised of the allegations. We're not law enforcement. We're not trying to play tricks. We're going to tell you what that allegation is. We're not going to just start the investigation and be like, so tell me what happened. You're going to know what that allegation is. We can't disclose who the reporter is. That's confidential information, but you will know what those allegations are. We're not trying to trick or deceive you. And then be advised of our process, who we're going to interview, and then documentation that we're going to gather, and then be interviewed, and then you can give your statement to that investigator. Be advised, of the evidence that we have. We're not going to, so if I have this video that shows you hitting this kid, what would you say? We're not doing that. We'll let you know. A lot of times the investigators will watch video with the staff. Walk me through this. What happened? What was going on? Sometimes videos look a lot different than how they actually happen. So we have that staff member go over those videos with us. So we're not going to hide that evidence. You also can submit or supplement a written statement. If you've had your interview, you think about additional information you want to add, and you'd rather do it in a written statement, you can always do that. You can also contact that investigator, say, hey, I really want to meet in person. There's additional information I want to talk to you about, or can we do it over the phone? You can seek and receive advice from other parties. You can seek, representation from an attorney. You can have that attorney present. We have different rules if that attorney is present of how that interview would operate. And then you can decline to answer any questions that you think will self-incriminate. If you feel that this is probably going to be pursued by law enforcement, then you have the right to not answer some of the questions if you think it will self-incriminate. And then you're going to be notified in writing by our office of the outcome of the investigation. So during your interview, you're going to be asked to provide your home address. And statute says we have to mail the findings letter to your home. There's no guarantee if we send it to your place of employment that they're going to give it to you. We can't prove that you got service. So if you have a substantiated finding, you'll get a certified letter so that we can prove that that service was made. So we ask that you respond fully and truthfully to questions unless you refuse based on self-incrimination, and then refrain from any action that may interfere with the investigation. We have had staff before that have heard that, a kiddo made an allegation against them, and they're going to go talk to that kid and try to threaten or intimidate that kiddo, or talk to the other peers and be like, hey, look, he made an allegation against me. I need you guys to go take care of him. You can't interfere in the investigation like that. So completion of findings, we have 30 days to complete our investigation. And then we have a substantiated, unsubstantiated, and a ruled out finding. So substantiated, we have a burden of proof of some credible evidence. So based on some credible evidence, we have information that this abuse or neglect did occur. In our policy, which is all public, it gives different substantiation protocols for all of our allegations. If it's neglect, if it's sexual abuse, if it's physical abuse, that failure to protect, threat of harm. We have certain things we have to meet in order to substantiate that allegation. Unsubstantiated means that we just don't have enough information maybe. We can't tell, we can't meet that burden of some credible evidence. We may think, something may have happened. We just can't say that it was some credible evidence that abuse or neglect happened. And then ruled out means that we can say with certainty that abuse or neglect did not occur. Maybe something's just clear as day on video. We had one kiddo that said this certain time, this certain day, this staff came in and punched him in the face. One, that staff wasn't working that day, and this kiddo was adamant that it was this specific day, this specific time. So the staff wasn't working. We went ahead and watched video for that specific time frame, and nobody entered that child's room. So we can say there that what that allegation he's making, we don't have any evidence to support that. So the caretaker misconduct finding. You may have an unsubstantiated abuse or neglect finding, but have a confirmed caretaker misconduct. So it's not abuse or neglect. Again, it's that violation of that policy, procedure, that rule. So we have some facilities that they use restraint techniques that don't have a floor restraint. So maybe that facility, they restrained on the floor, but it wasn't abuse or neglect. Nobody was hurt, everybody was under control. But because policy says you can't restrain on the floor, you broke that policy. So that's a caretaker misconduct. Or maybe engaging in a restraint when that child really wasn't a threat to themselves or others. We get staff that get engaged in power struggles and they're just ready for the situation to be done. So if I put this kid in a restraint, they'll de-escalate and we can move on with our shift. The restraint itself could have been textbook perfect, but the reason for the restraint didn't meet that threshold. So it would be that caretaker misconduct. So any acts or omissions too that contribute to the delinquency of a child. Again, that 17-year-old that may be in a substance abuse program and, a staff gives them a cigarette. It's not appropriate, but it's not really abuse or neglect based on this kiddo. Using profanity or kind of abusive language that doesn't rise to that level of, those degrading statements or that mental injury. It's just not professionally appropriate. So those are examples of the misconduct. So we get a lot of questions from staff that you'll get your findings letter and it says, hey, I was unsubstantiated. But then your supervisor is going to come and maybe want to talk to you about this confirmed misconduct finding. So there are two separate findings and two separate processes. So your notification of findings, you'll get your letter in the mail. And then that facility also gets a summary of the findings and then areas of concern that we identify. So they have all of the findings, and then maybe with that misconduct, we kind of identify an area of concern that, the staff kind of lost their temper, engaged in this restraint when it really wasn't warranted. So then that's the support for that misconduct finding. So program reviews. If you have a substantiated finding of abuse or neglect, then you can ask for that to be appealed at a program review. Caretaker misconduct is not abuse or neglect, so it does not have the same appeal process. So you can request, you'll get your letter in the mail, and on there are specific time frames. It's 45 days. You'll actually get 2 letters. So one that just comes regular mail and one that's certified. So the regular mail, it's 45 days from the postmark on there, or 15 days from the time you sign the green card. To sign and return that form to our office to request that program review. And then you'll get a letter in the mail stating that that program review has been accepted. There's 2 reasons why you would be denied that program review. One is if you miss the timeframes, and 2 is if there's pending criminal charges for that specific abuse or neglect. So if you broke a child's arm and law enforcement has decided to pursue charges of abuse, you don't get that appeal. That will be heard through the criminal system. Sometimes with timeframes, there's been situations with mail that if that person has explained, and there's a reasonable explanation as to why that time frame wasn't met, we can make those exceptions to accept those appeals. And then there will be once a month on the second Wednesday, the committee meets to review all documentation. So one thing I stress kind of in these trainings when I talk about documentation is I stress it to my staff, and then I also stress it to you guys. The documentation is key. So in incident reports that you document, if there's a restraint, a situation, make sure that you document clearly. I know that you're tired, you're ready to go home. I worked direct care previously, and you don't want to sit down and write out all that information. But if an OCA investigation happens, those incident reports are crucial as to those details that you're not going to remember. It may be a couple of weeks if something doesn't get reported timely that we come out to ask you about it. And what if you've been in 5 other situations with that same resident? Things are going to get kind of jumbled. So those incident reports are critical. It's the same as I stress to my staff for program review. Myself and anybody involved with the investigation is not part of the program review process. So what they look at is the report that we create and any supporting documentation. So if we don't document in our report clearly, then that finding may not be upheld because we didn't document as we were supposed to. So as much as I tell staff at the facilities to document for their incident reports, I tell my staff as well for the program review, because they're only looking at that report and any documentation that we gather. If we have a doctor, our kiddo went to the doctor and the doctor's saying that this is 100% abuse, but we didn't talk to that doctor and we didn't get that medical information, then it's really not a pertinent part of our investigation because it's not in there. So the review will be completed within 120 days, and you'll get notification of that process. So you also have the right to submit any statements from yourself or any other peers, people you were working with, people that witnessed the incident, anything you want to send in to be considered by that committee, you have the right to do that as well. So the committee is comprised of, there's a program field rep for our grievance division, and she kind of goes through the meeting, she monitors it. And then we have a programs administrator for our advocacy division. So our division, we do advocacy services, the investigations we're talking about today, and then vulnerable adult investigations. We also handle grievances from foster parents and then also from kiddos that are in out-of-home care. So it's people that are within our office, but they don't have anything to do with the investigation. They also are not voting members, so they just kind of facilitate the process. So the voting members are going to be somebody from the CPS Programs unit, so child welfare. Also from licensing, we have somebody there from SPPU and from OJA. So those are the voting members. It's not people that had anything to do with the investigation or employed in our office. And then, so they go over, if there's video, they look at the video, they go over the report. They have discussions. They don't always agree on the vote. And they each do, it's a silent vote, so they write it down and then send it in. After that, you'll get notified whether that finding was upheld or overturned. So critical incidents, we kind of talk about things that happen but might not be abuse or neglect, but still have to be reported places. So critical incidents. So if I have a, death of a resident or employee, it still has to be reported, to somebody. Let's say, that kiddo was missing from care for months, and something happened and that kiddo passed away. There's no abuse or neglect on the staff, on the facility, because that kiddo had been missing from care. But somebody still needs to know about that you guys were notified of that child passing away. Any situation, if there's abuse or neglect, you still report it to the hotline and complete that critical incident report. If there's like an act of God, a tornado, or something, a flood, it's not abuse or neglect. You couldn't have done anything to prevent that. So it's a critical incident, but it doesn't need to be reported to the hotline. And then an event of a juvenile that receives, services or something that happens that gains media attention. Again, if they were missing from care, it's not abuse or neglect on the staff because they weren't at the facility under the facility supervision, but a critical incident report still needs to be completed. So kind of what happens with those? So we get a lot of staff that are, well, I filled out the incident report. Isn't that good enough? Or I filled out the critical incident report. Isn't that good enough? I let my supervisor know. Isn't that good enough? So kind of what happens with each process. If there's an incident report, so it doesn't rise to that level of abuse or neglect, there was a restraint, there was no injury, there's no allegations made, it was kind of just the best case scenario of a restraint, right? You still have to complete that incident report, that restraint report, to document that happened, but it doesn't result in a call, and it's not a critical incident. If a critical incident happens, then you notify that SPPU liaison. You'll also notify licensing, and if it's an OJA facility, you're going to let OJA know. So you're going to complete that incident report, and there's some additional notifications that you'll make. Then if we add abuse or neglect hotlines, you're going to follow all those procedures above, but then you're also going to call the abuse or neglect hotline. I will say, if you're going through an incident report and you're thinking in your mind, do I need to report this? Do I not need to report this? If you're having enough thought to question it, I would report it. So this just has our contact information for the Office of Client Advocacy. And then my cell phone number's on there if you have any questions. And then our CPS Programs Office, your Child Care Licensing State Office, that Specialized Placements and Partnerships. And then again, if you see it, report it. Our kiddos make the perfect victims. So we know they will continually make allegations. It's kind of the boy who cried wolf. But you'll get a staff member who thinks that's an easy target. No one's going to believe them. But it happens as much as we don't want it to. So if a kiddo discloses it to you or you see it, go ahead and report it. Any questions? All right. Thank you.